Hello, and thanks for joining me today. My name is Joseph Catton. I'm a third-year law student at Osgoode Hall Law School, and I'll be articling at a mid-sized litigation firm in downtown Toronto beginning in the summer of 2025. Under Heather's supervision, I am here to talk about the concept of judicial bias. And before we begin, please note this presentation is to be used for informational purposes only. It does not and is not meant to serve as legal advice. As well, this video is current as of March 2025. So please be aware the law changes, so do legal doctrines. They are not static things. If you have a legal matter requiring attention, please seek professional legal guidance and assistance, as every matter is unique. And here's just a brief overview of the presentation I will give today. I'll briefly cover the role of a judge and relevant considerations for appeals, the presumption of impartiality that's applied to judges, a few potential categories of bias that might arise, and then I'll dive into the test for a reasonable apprehension of bias and the associated evidentiary burden. I will then cover 3 cases to demonstrate how the reasonable apprehension of bias test is interpreted in case law. And I'll round off the discussion with some practical considerations, mainly targeted towards self-represented litigants. So first, what is a judge and what do they do? First, a judge is expected to manage proceedings accordingly in a way that processes matters in a fair and efficient manner. A judge may also engage in case management, settlement conferences, judicial mediation, and they will likely interact with self-represented litigants, which comes with its own sort of set of special considerations, which I will touch on later. Second, a judge is expected to consider the evidence presented before them and come to decisions based on this evidence. In common law courts such as Ontario, a judge does not engage in any sort of independent fact-finding mission. However, a judge may intervene in proceedings. They may ask questions. They're not expected to be passive or silent. For example, they can speak up and ask a question to seek clarification. And third, judges issue judgments that are final and binding on parties, subject to appeal. So speaking of appeals, let's say that you had a matter that concluded at trial. And that you received a judgment for this. Let's also say that you have a belief that that bias affected the trial and the subsequent decision. What are some things that you should be aware of if you want to appeal the decision? So you first need to be aware that the appeals court will assume a few things about a trial judge. They'll assume that the judge treated parties fairly and did not prejudice either side. They'll assume that the trial judge based judgments on the evidence before them, like I said, and on the applicable laws. And they'll assume that the trial judge explained the rules of court to self-represented litigants, but that they did not assist self-represented litigants in the matter. An appeals court will also afford a judge what's called wide deference. So in other words, appellate courts will not meddle with a trial judge's decision. By and large, they will respect a judge's decision as it's written, for example, on interpretation of evidence or management of the proceedings or the trial, so long as the judge did not commit an error of fact or law. If appellate courts began meddling in decisions, this might undermine the role of a trial judge and the respect that a trial judge is owed. Second, an appellate court will afford a trial judge the presumption of impartiality. So impartiality means a few things here. It means that a judge has not prejudged or predetermined the outcome of the matter, that a judge has not closed their mind off to other arguments, and that a judge remains capable of being persuaded by either party. Continuing with this presumption of impartiality, it's a long-standing and widely respected principle within the Canadian legal system. It reflects the duties that judges take an oath to uphold. And judges take this duty very seriously, and the courts recognize this. The ethical standard is reflected in a document published by the Canadian Judicial Council called the Ethical Principles for Judges. which judges are expected to familiarize themselves with and sort of espouse the values written within such a document. The legal standard is reflected in the common law. For example, decisions from the Supreme Court of Canada and the Court of Appeal affirm that the presumption of impartiality exists to maintain public trust in the legal system. It's also expected that judges will be vigilant of any factors that might lead to an appearance of bias, and they're expected to act on any beliefs that they have that they might appear to parties or to the public in general as being biased. This might include posing the potential grounds to parties to seek their feedback on whether the judge, should maintain the role of hearing the matter, and it may ultimately end up in a judge recusing themselves from the matter. And I'll say that in the vast majority of cases, it is the judge's own motion that they submit that leads to their recusal. Just because judges do take it very seriously that they do not want to give off any sort of appearance of bias. They respect the ethical principle that they owe the public a duty to appear as impartial and professional triers of fact. Thirdly, judges are not expected to be completely neutral. So they're humans just like you and me. They're not expected to discount or forget their life experiences. They're not expected to have a so-called blank mind during proceedings. They must address evidence as presented, but their experiences may influence how the judge interprets or treats certain evidence or manages the trial. Trials in court proceedings are also, they're not considered a tea party, and the court recognizes this. In other words, the court's not there to hold anyone's hand or make it a fun, enjoyable experience for anyone. Judges have a duty to maintain a level of courteousness and respect and decorum with litigants involved in proceedings, but certain outbursts of frustration or irritation, human reactions by a judge are permissible, especially in complex, lengthy cases or cases where emotions are running high, for example, family law or custody cases. So this slide just highlights 6 categories of bias that might arise. It's not a list that's set in stone. It's more of a way to conceptualize how bias might come about, or how someone might categorize bias if they were to write a motion requesting a judge to recuse themselves, or write an appeal that is grounded on bias that is arising. I won't dive into these too deep because I believe the titles are relatively self-explanatory, but we'll cover some of these when I go over specific examples of cases later on.